So hello, everyone, and I'd just like to say thank you for the warm welcome that I've received so far here in Melbourne. I met Becky and Kate last summer when they were in Toronto for a Law and Society Association conference, and we talked then about my hope that I would be able to come to Australia for my sabbatical, and so it's just really great that it's worked out, and I'm very, very honored to be part of this first seminar series of the Feminist Legal Studies group. So, as Becky mentioned, I am a part of a research team that has, in Canadian terms, a fairly large research grant for a multi-year cross-Canada project that's looking at domestic violence and access to justice. You've already heard about our team members, and so Janet Mosher and Wanda Wiegers are my co-authors on the research that I'm presenting this afternoon, and we have also as collaborators Wendy Chan and Michaela Keat. We have three different phases of the project that I'm going to speak about this afternoon. So when Becky asked me for a title for my presentation a couple of months ago, I thought that I would be focusing on the case law research, and I will talk about that today, but I thought it would be interesting and important to put that case law research into a broader context. So I'm going to talk as well about the first phase of our project, which was one that mapped all the legislation in Canada that's pertinent to domestic violence in all 14 of our jurisdictions. Then I'll talk a little bit about our case law research, which is still at its beginning stages. And then I'll talk about the third phase of our project, which is going to involve interviews with people involved in the justice system, as well as litigants who have been going through domestic violence cases. So the premise for our research project, and this will probably come as no surprise to most of you, is that domestic violence cases present unique challenges, both in terms of the power dynamics, structural inequalities, and gendered nature of domestic violence, but also because victims, offenders, and children often have to navigate multiple legal systems. Those legal systems can intersect in ways that present particular access to justice challenges. So we take as a starting point in our research that because different legal systems have different objectives, different standards, that may place especially victims in a position where they're being told to do different things by different systems. Maximize contact with the other parent in the family law system, for example, but restrict contact with that parent in the child welfare or child protection system if that might result in harm to the child. The other thing, of course, about having all these different intersecting systems is that can lead sometimes to conflicting outcomes for litigants, and those conflicts can sometimes impair the safety of victims and their children. In addition to these issues being gendered, the research also shows that domestic violence is more prevalent amongst some marginalized groups, and they can also be affected by different legal systems that come into play in their contexts, including immigrant and refugee women and Indigenous women, as well as women living in poverty. So with that starting point, I just want to provide a bit of social context for family violence in Canada. The most recent report is from 2018, which provides statistics for 2 years prior to that. And I think it's important to note that family violence has quite a high proportion in Canada as a percentage of all violent crime in our country, and that 79% of all police-reported intimate partner violence is against women. So strong statistical support for the gendered nature of family violence in Canada. At the same time, we have relatively low reporting rates for spousal abuse to police. Indigenous women and women identifying as lesbian or bisexual do report at a slightly higher rate than non-Indigenous women and heterosexual women, but overall reporting rates tend to be low. The other thing we have is a legal context that's similar in some ways to Australia. We're a federal system in Canada. We have both federal laws and provincial laws as a result of division of powers in our Constitution. So in Canada, federally, that government is responsible for criminal law, for divorce, as well as corollary matters leading from divorce, including custody, access, and support issues. Immigration and refugee law is dealt with federally, as well as the law related to Indigenous peoples. And then we have 13 provinces and territories in Canada, and they are responsible for the administration of criminal justice. So criminal prosecutions is administered at the provincial level, even though criminal laws themselves are federal. Civil protection order laws in family violence cases are also dealt with provincially. Family laws other than divorce are dealt with at the provincial level, so where parties are not married, or sometimes even where they are married, but if they choose to go around the Divorce Act or use provincial legislation other than the Divorce Act, that's something they can do. Child protection laws are provincial. Social assistance and housing laws and residential tenancy laws are dealt with at the provincial level. Employment laws are mostly provincial. There's some federally regulated sectors of employment in Canada. And civil actions for assault and battery are also handled provincially, as well as limitation periods for those actions. So very complex legal jurisdiction, again, not dissimilar to what you have here. Layered on top of that is the fact that we have many different levels of court. We have courts at the provincial level, as well as tribunals at the provincial level. They hear criminal law matters. They also deal with issues related to family law and child welfare other than divorce, which happens in our superior courts. They handle civil protection orders and other civil matters, social assistance, tenancies, and employment. Then at the superior court level, they also have jurisdiction over criminal matters, but of the more serious kind. Divorce, as I mentioned, and matrimonial property issues are dealt with there, and civil matters where the dollar amount is above a particular level. Then we also have a separate system of federal courts, and that's where immigration and refugee laws are dealt with. And so this complicated court system is, of course, layered on top of the legislative regime that I just mentioned. A couple of definitional points about our research as well. We're focused primarily on what we're calling domestic violence. I know there's a lot of debate in the literature about the proper terminology to use, but we tend to use the term domestic or family violence because that's what that social harm is typically called in the legislation that we're focusing on. But our main focus is on adult intimate partner violence. So we touch on elder abuse and family violence as it relates to children in our research, but our primary focus is on intimate partner abuse. Also, our project is focused on access to justice, as I mentioned. And I think it's important to note that we take quite a broad definition of access to justice, not just access to lawyers and legal advice, but also more substantive notions of access to justice that relate to substantively just outcomes. We also try to approach our work from the perspective of litigants. So what are their unmet legal needs? How have people been marginalized by social institutions, including law, and how does that affect their access to justice? We also take the view that some of the barriers that are faced by litigants in the domestic violence context are unique for the reasons that I mentioned earlier, because of the power dynamics, because of the intersecting legal systems, and so on. What do we mean by intersecting legal systems? What we're interested in are the way that processes from one legal regime can have an impact on another, whether positive or negative. So we could be talking about inconsistencies across legislation. How is domestic or family violence being defined? Are there adverse consequences that flow from these different intersections? So what happens when one statute or legal regime fails to take account of another, and that results in negative consequences for the parties? Or are there actual conflicts in either different legislative regimes, the objectives behind them, or some of the legal remedies that can flow from those different legal regimes and remedies? So that's what I mean by intersecting legal systems. So I mentioned that we have 3 phases to our research. We've completed the legislative and policy mapping phase, where we mapped or sort of documented, I guess, all of the different laws and government policies that relate to domestic violence in each Canadian jurisdiction, which is the federal jurisdiction and the 13 provinces and territories. We've also compared the laws across all of those jurisdictions, and I'll show you a chart in a few minutes that's a bit of a snapshot of that. And we've tried to analyze the different intersections in each jurisdiction, with intersections defined as I just mentioned earlier. We also have additional funding from the Law Foundation of Ontario's Access to Justice Fund to create a website to provide access to this information in what we hope will be an accessible format to what we're calling trusted intermediaries. I'm not sure if you use the same term here, but trusted intermediaries in the Canadian context are those who provide frontline services to victims and offenders in the domestic violence context. And so what we're hoping to do is to create an important informational source for those trusted intermediaries, so that when people come to them for advice on domestic violence, they'll be able to have access to that information about how laws and policies intersect and what the implications for their clients might be. And I should pause to thank my funders, the Social Sciences and Humanities Research Council, and also the Law Foundation of Ontario Access to Justice Fund, as well as Moody's LLP, who helped fund my trip to Australia. So I'm not going to go through these slides in great detail, because they're mostly descriptive, but a few things that I want to point out. Under our criminal law, we don't have any specific offenses related to domestic violence, and I understand it's the same situation in Victoria. If I'm right on that, there's no specific domestic violence related offenses?
No.
Okay. So similar situation there. So for crimes of domestic violence, we're looking typically at things like assault, sexual assault, criminal harassment, and charges that are more general in nature. Domestic violence is mentioned specifically in our criminal code when it comes to interim release. And so if it is a situation of domestic violence, the presumption is that there will be a no contact order in those circumstances, unless the complainant requests otherwise. There's also particular sentencing provisions for domestic violence in the criminal code, so it's considered to be an aggravating factor at the time of sentencing, and also provisions for no contact orders in the probation context after sentencing. We also have peace bonds in the criminal code, which are a remedy that's used quite often by specialized domestic violence courts in Canada. So peace bonds are essentially an undertaking that usually the person has been accused of a crime, and it's a way of them resolving their legal matter without obtaining a criminal record. So if they admit to at least some aspect of what's alleged against them, often what our specialized domestic violence courts will do will be to use a peace bond that includes no contact provisions for a period of time. There's a lot of controversy on that as a legal remedy. Does it adequately take into account offender accountability, which is such an important principle in domestic violence cases, but I won't get into that now, just to tell you that that's something that exists under our law. Divorce, as I mentioned, is also federal law in Canada. Currently, there's no specific reference to domestic violence in the Divorce Act, but there are reforms before our Parliament currently, which would include domestic violence as a factor relevant to making parenting decisions, relevant to the best interests of the child for the purposes of making parenting decisions. And that bill is expected to pass. What we do have in our Divorce Act, and this is similar to some of our provincial laws, is a maximum contact principle. So the idea that after a separation, the custodial parent will try to maximize contact with the other parent to the extent that that's consistent with the best interests of the child. And that goes hand in hand with the friendly parent provision. So the custodial parent is expected to facilitate that sort of access. And if not, that can have consequences for the legal proceedings. Under immigration and refugee law, domestic violence comes into play in terms of spousal sponsorships and also in terms of criminality. So immigrants can be deported back to their country of origin where they've engaged in criminal offenses. My colleague Janet Mosher is especially interested in research in this area and is looking at how revocation of sponsorships by abusive partners is often used as a form of abuse. In terms of the laws related to Indigenous peoples, there's federal legislation dealing with matrimonial property on reserve. So our First Nations people in Canada, we have three categories of Indigenous people as per our Constitution: the Inuit people who live in the north, First Nations peoples who, if they have so-called Indian status, live on First Nations reserves, and also Métis people. And for those First Nations peoples who live on reserves, their lands are under the control of the federal government. And there are now specialized matrimonial property laws that deal with how those lands should be dealt with in the case of marriage breakdown. That legislation also provides for civil protection orders for First Nations people living on reserve. And I think quite importantly, it also provides for First Nations themselves to create their own matrimonial property laws, including their own laws for handling domestic violence disputes on their territory. It still, of course, is colonial legislation, so I don't want to present this as being Indigenous law, but it is at least a recognition of some jurisdiction on the part of First Nations to create their own laws. Only 13 First Nations in Canada have done so to date. And I have a graduate student, Elisa Darling, who is looking at this issue in her graduate work. So that's the federal scheme. Moving to the provincial and territorial scheme, as I mentioned, the administration of criminal justice is handled at that level. And so all provinces and territories have both police and prosecution policies that are essentially zero tolerance policies, in the sense that there should be or will be charging for domestic violence and prosecution of domestic violence cases, provided there are reasonable and probable grounds to do so. Of course, that's not always followed in practice, but those policies are there. Many provinces also have specialized domestic violence courts, which operate at the criminal law level. So we only have one integrated domestic violence court to date, and that is in Toronto, and it hears both criminal and family law matters. Under the administration of justice, we also have victims' rights and victims' compensation legislation, which doesn't refer specifically to domestic violence, but it does provide victims of domestic violence with compensation. We also have civil protection order legislation in almost every province and territory except two. They provide for no contact and exclusive possession orders, which may be inapplicable on First Nations reserves, given that jurisdictional split between the provinces and the federal government. And in particular, there's some case law suggesting that exclusive orders for the possession of matrimonial homes are not effective on First Nations reserves, which was part of the need to bring in the First Nations matrimonial property legislation I mentioned earlier. So I think what that example does is really highlight how for Indigenous victims of family violence, it's a very, very complex jurisdictional picture that they face. The other thing that's interesting in comparing civil protection order legislation across Canada is the extent to which emotional, psychological, and financial abuse is included, and it's in about half of our jurisdictions, I would say. Family law, apart from divorce, as I noted, is under provincial and territorial law. In many provinces, domestic violence is explicitly listed as a factor that's relevant to the best interests of the children when it comes to making parenting determinations. There may also be maximum contact and friendly parent provisions in those laws. And all of our provinces have adopted the Hague Convention on International Child Abduction. Child protection laws, similarly, domestic violence may or may not be an explicit factor when it comes to whether a child is considered to be in need of protection. In all of our provinces, there is a duty to report children who are in need of protection by anyone with reasonable and probable grounds to do so. So this duty exists not only on the part of professionals like teachers or health care workers, but anyone who has those reasonable and probable grounds must report a child as being in need of protection. Again, whether that duty is fulfilled, even by the police, is something I'll talk about a little bit later. The other thing that we have been interested in mapping, and this relates especially to the research of my colleague Michaela Keat, is alternative dispute resolution laws. And in some provinces, domestic violence is explicitly listed as a factor in family law legislation in terms of whether mandatory alternative dispute resolution should be imposed on the party. So it may be an exception that allows the litigants to get around mandatory ADR. I mentioned earlier the reforms to our Divorce Act that are currently before our Parliament, and that legislation does not include provisions looking at domestic violence in the ADR context. So there's a number of organizations in Canada right now who have submitted briefs to Parliament suggesting that amendment should be made to the bill. At the provincial level, some provinces do require that mediators and arbitrators, other alternative dispute resolution professionals obtain training on domestic violence issues and must screen for domestic violence issues. But again, that's not consistent across the country. In our residential tenancy laws, in many provinces now, tenants may terminate their leases early if they're living in circumstances of domestic violence and have to flee the premises. We're not so good in Canada at creating conditions for victims to be able to stay in the premises. And just for an example, the rules around changing locks are ones that only allow for the tenant to do so. So if the victim's name isn't mentioned on a lease, she wouldn't be in a position where she could lock out the perpetrator. And tenants, even if they're victims, may also be faced with having to leave the premises if the landlord terminates the tenancy because of illegal premises, even if they were not the cause of that illegal activity. So we've made some strides in the residential tenancy area, but we still have some way to go there. In terms of social assistance laws, in many provinces, there are explicit references to domestic violence that are designed to provide supports for moving, transportation costs, and so on. Employment laws now in several of our jurisdictions permit employees to take leave from their employment for reasons of domestic violence. And in some jurisdictions, there are occupational health and safety laws that impose obligations on employers to take steps to prevent their workers from domestic violence that may occur in the workplace. Limitation periods have been either eliminated or greatly expanded in some jurisdictions to provide better access to civil lawsuits for domestic violence. In terms of privacy laws, we only have one province, British Columbia, that specifically refers to domestic violence in its privacy legislation. But in most of the other jurisdictions, there are requirements in privacy laws that relate to disclosure that's necessary for a person's mental or physical health or safety, and those provisions would be relevant in domestic violence cases. And then insurance law is another area where domestic violence can be relevant, because if property damage occurs as a result of a domestic violence related crime, in many provinces, victims aren't able to recover under the insurance policy unless there's a so-called innocent third-party exemption, and some provinces have moved to that now. So that gives you a bit of an overview of all the different laws and provinces that we have mapped across our 14 Canadian jurisdictions. And this is just a snapshot representation of what the picture looks like currently, and it is moving at a rapid rate. So one of the things we're going to have to do, and this may be of interest to any law students or other legal researchers in the crowd. Because things change so quickly, of course, in the legal realm, we've had to create a huge system of alerts so that every time one of these statutes or regulations is updated, we can update the materials that we'll eventually have on our website. To go into the intersections a little bit deeper in the context of my own home province, Alberta, I just want to highlight a few things that comes out of this mapping research to show why I think it's quite important. So we do have civil protection order legislation in Alberta, which applies to family members in cases of family violence. It has, I would say, a moderately broad definition of family violence, which includes physical and sexual harm. It also includes stalking, but it doesn't include dating relationships. It doesn't include emotional or financial abuse. We have child protection laws that do stipulate domestic violence as a factor that's relevant to the best interests of the child. Same thing in our family laws. We now have residential tenancy laws that allow for early termination, as I mentioned. But one example of an important intersection in Alberta is that domestic violence is defined differently under the Residential Tenancy Act than it is under the Civil Protection Order legislation. Yet getting a civil protection order is one of the ways that a victim can prove that she's been a victim of family violence for the purposes of getting a remedy under the Residential Tenancy Act. So if she's unable to get an emergency protection order under one statute, because of the narrower definition, she's going to have to use other means to try to prove domestic violence under the Residential Tenancy Act, which we see as being a problematic intersection between those two acts. Similarly, under our social assistance laws, there are benefits available to victims of domestic violence, but social assistance may be refused, suspended, or reduced where the recipient has unreasonably refused to pursue financial resources that they're entitled for, which may include child support against the father of their children. So that's another way in which the intersections between these two acts may not account for some of the barriers that women may face, including actual safety issues if they try to obtain that sort of support. On the more positive side, under our social assistance legislation, where a woman is a sponsored immigrant and she's been abused or abandoned by her partner, then those usual obligations to pursue that sort of support may be excused. Employment law is a relatively new development in Alberta. It defines domestic violence the same way that it's defined in the Residential Tenancy Act, so broader than it's defined under civil protection order legislation. So there may be circumstances where those who would be considered victims under the employment statute would not be considered victims under the civil protection order legislation. Under our victim compensation legislation, victims may be denied compensation if they haven't pursued charges against the perpetrator of the offense. So that's an important intersection between our compensation laws and the criminal regime. And then I'll just mention that we have a number of domestic violence courts in our province, but as yet no integrated domestic violence courts. And I think there's some interesting research out there looking at whether integrated domestic violence courts might be a way of trying to do a better job of handling some of these intersections. So that's the first phase of our research. The second phase is our case law research. And what we're interested in exploring here is what the case law from 3 of our provinces reveals about how judges account for challenges in their treatment of domestic violence and related issues, especially those that arise when they're faced with intersecting laws and legal systems. We also wanted to take a look at to what degree judges take account for any complexities that may be presented by the litigants' identities. So if they're Indigenous people, if they're immigrants or refugees. We picked the 3 provinces of Alberta, Saskatchewan, and Ontario, which happens to be where myself and Wanda and Janet are from. But one of the reasons we think these are an interesting set of provinces to compare, is that we have different legal regimes. So in Alberta and Saskatchewan, we have civil protection order legislation. Ontario does not. In Alberta and Ontario, domestic violence is an explicit consideration under our family law. In Saskatchewan, it's not. And then under the child protection laws in Alberta and Alberta and Saskatchewan, domestic violence is an explicit factor, and in Ontario it's not. And so comparing the case law from these three different provinces allows us to explore whether differences in how laws are constructed actually makes a difference in how judges are handling these cases on the ground. What we did to identify the cases for our study was to focus on family law cases because we thought that those were probably going to be the most likely cases where intersecting legal areas were discussed. So you don't see family law issues discussed very often in the criminal context, but in family law cases you sometimes see judges talking about the presence of criminal charges or involvement of child protection authorities or that sort of thing. So we searched case law in our three provinces for a span of 7 years using search terms that would be likely to find family cases involving domestic violence. We read all of the cases in Saskatchewan and then did a sampling of cases to come up with a similar number in Alberta and Ontario. And then we narrowed our sample of cases, at least for this phase of our research project, to look at family law cases only. So we've excluded child protection cases for now, involving parenting issues. So we excluded cases involving support or property issues, where there are intersections with other legal systems or other laws. And you can see the numbers from the screen there in terms of the number of cases we've analyzed. So what we've done is to go through these family law cases and try to quantify certain things. So to what degree do family law cases involve civil protection orders? And interestingly, even though both Alberta and Saskatchewan have civil protection order legislation, the legislation seems to be used much more often in Alberta than it is in Saskatchewan. And Ontario doesn't have that sort of legislation, so the numbers there reflect restraining orders that are obtained under family law rather than specific civil protection order legislation. We also looked at the number of cases involving criminal charges and who those charges were brought against. Saskatchewan, now the 100% number probably looks vast, but keep in mind that that's 100% of the cases involving intersection. So by definition, these are cases that involve some other legal regime in addition to the family law regime. Yet I still think it's pretty significant that those intersections, 100% of them involve criminal charges, with lesser percentages in both Ontario and Alberta, but still fairly significant. We also mapped the level of child protection involvement in the cases. And interestingly, Ontario, even though domestic violence is not an explicit factor that's mentioned in their child protection legislation, had a very high, the highest percentage of cases involving child and family services involvement of all three provinces. We also found that the courts are not particularly good at identifying whether the litigants come from marginalized groups. So these numbers we expect are smaller than the actual percentage of marginalized litigants involved in these cases. But we didn't find any cases involving either same-sex relationships or transgender parties in any of our jurisdictions. And the number of Indigenous litigants and racialized litigants was relatively low as well. We expect to see a much higher percentage of Indigenous litigants in the child protection cases when we come to analyzing them. Although again, the courts aren't always good about making an explicit identification there, and you have to look for other ways of trying to identify those cases. So I know I'm running out of time. I'm just going to quickly mention some of the themes that we've found so far, and these are very tentative because, as I mentioned, we're just at the beginning stages of this research. On the question of whether criminal charges or civil protection orders seem to make a difference to family law outcomes, it's typically only if those criminal charges result in convictions that there seems to be a connection in the cases that we've read. And civil protection orders seem to make very little difference to family law outcomes. The other thing that we found in the cases is that domestic violence tends to be defined quite narrowly, and that few of the cases that we've looked at consider things like emotional or financial abuse or coercive control. The way that courts are looking at domestic violence, even in family law cases, is very much from a sort of criminal definition. And often domestic violence receives very little analysis at all. It may just be mentioned in the case as a background fact and then not really be assessed by the court, even where it's an explicit factor relevant to the best interests of the children. So through the different examples that I've presented you with, it seems that different legal regimes perhaps don't make as big a difference as we would have thought they did in the actual analysis of parenting decisions by family law courts. And I've just given some examples there in addition to the ones that I've mentioned. The other thing that we're looking for in the cases is the way that the presence of other legal proceedings can be used often by the abusive partner to try to make allegations of fabrication or manipulation on the part of the mother or of alienation. And we have all found several cases in each of our jurisdictions where the presence of child welfare investigations, the fact that the mother has brought emergency protection order proceedings or has reported a matter to the police have all been used against her as a way of trying to argue that she's manipulated the system, et cetera. And in some cases, those arguments have actually resulted in positive findings of that behavior by the court. It's been rejected in others, but I think it's important that in some cases, courts are accepting these arguments. That leads to the idea of court harassment or abuse. So when abusive partners are actually using the legal system itself in a way that is furthering the abuse, and those kinds of practices have only been recognized in a few cases. Courtroom behavior seems to play an important role for the court. So if a litigant behaves badly in court, that may have just as much to do with the outcome of the case as their past behavior in the family. And there's very little discussion that we found of parties who are Indigenous or racialized, although we do have a couple of cases in Alberta and Ontario where fathers have alleged that the system that they're having to contend with is racist. There's also very little guidance by appellate courts on any of these issues. So we are going to be doing further analysis of the body of cases that I've mentioned, as well as some of the other cases that we excluded from this sample, including child protection cases and so on. So that this phase of the project is continuing. And then we'll be interviewing litigants, because I think what our mapping research and our legislative and case law research has showed is that you can only get a partial picture of what's happening in family violence cases from the laws and the way that they're being applied by the courts. And we really need to talk to justice system personnel and litigants themselves to get a real sense of what's happening on the ground. So that will be the next phase of our project. So that's our research project, and I'm happy to answer any questions that you have.
Thank you. Any questions? Thanks, Heather.
Thanks very much, Jennifer. That's a really very clear and interesting presentation. Just a bit distressingly similar to the situation at stage, family law, child protection, domestic violence cases. The problem we continue to struggle with here, as I'm sure you're struggling with. I have two questions. One is that I wondered if you, how do you explain you have got some even kind of assumptions about the difference in Ontario compared to Saskatchewan and Alberta is about child protection substantially higher proportion of those cases.
Yeah. So from what Janet has gathered, because she's the one focusing on the Ontario case law, is that as soon as the police are called, they automatically report to child protection authorities in Ontario, and that does not seem to be happening to the same degree. Yes. Yeah, but we have the same policies, and in fact, we have a statutory duty in all three of the provinces, but it just seems that they're being handled.
I mean, is there a difference in the demographic makeup?
Toronto is probably the most diverse of all three of our cities. Saskatoon has a fairly high Indigenous population. We're looking at the provinces as a whole, but I think that's probably fair to say. So yeah, that's the importance of the interviews again, is to see just why those kinds of differences exist.
So the second question, I was tweeting, so I don't find understanding.
That's fine.
So I'm a bit distracted, but in terms of the definition, is there a common definition across the legislation of domestic violence?
No, it depends on, so even within jurisdictions, that's the point I was trying to make about in Alberta. Even in my own province, we have inconsistent definitions. So certainly across the provinces, there's very different definitions. BC has the broadest definition in its family legislation, which does include coercive control. There are cases in other jurisdictions where courts have recognized coercive control, but so it may be that having a legislative definition that's that broad may make somewhat of a difference, but we only have the one.
Control and overarching context, like it is in our family law.
It would depend on the statute. It would very much depend on the statute.
What might be an overarching context for a list?
Yeah. So I think one of the things, like ultimately what we want to do through this project is make recommendations for reform of the justice system. And I think probably one of the things that we're going to recommend is that there is more of a systemic approach and perhaps more of an adoption of those sorts of umbrella terms that would be consistent across legislation. Although, living in a federal state, you probably know how hard it is to sometimes get provinces or states to agree on ceding ground when it comes to their constitutional jurisdiction, or the federal government for that matter.
Any other questions?
It was very heavy on the words, and I felt when Ibunani and Kate were presenting their slides, I thought, oh my goodness, I've done the thing you're not supposed to do with PowerPoint slides, which is walls of words. But anyway, I'm sorry I didn't have more pictures, and I'm sure there's a lot to digest there.
I had a question about whether or not you are engaging in some qualitative analysis of women's experiences of what going to competing and parallel courts actually or systems means for them.
Yeah, so that's what we're hoping to do through our litigant interviews.
Okay. Fantastic.
And I should mention
I was
too,
also tweeting, so I didn't have.
Yeah, no problem. But I should mention that we're focusing on specific populations in the 4 different jurisdictions where we're going to be doing those interviews. So we're focusing specifically on immigrant and refugee populations in Vancouver and Toronto. So those are the litigants we'll be interviewing there. And then we're looking at Indigenous populations in Alberta and Saskatoon. So trying to get a sense of the specific access to justice issues that these different populations have faced, and then trying to do some comparative analysis across our provinces.
I had a student who came and saw me when I gave a presentation recently around family violence, and she was talking about, she works at an organisation where they have lots of migrant women, and that she was talking about that there are lots of organisations to help set up with migration status. There's lots of family violence organisations, and she's talking particularly about the case of women who don't even have visas to be here, so they're actually here illegally. They can't find anyone to help them with the whole of their problem, and that helping with part of the problem may actually make the other part of the problem worse.
Yeah.
And that there's no words to even describe the extent of their problem.
Yeah, and for anyone who's interested in issues affecting immigrant women, I would highly recommend Janet Mosher's work, not just affiliated with this project, but just her work more broadly, because that's an issue she's been working on for quite some time, and just looking at all the different complicated ways that these different laws and systems can intersect in that specific context.
Okay.
Thanks, Jennifer. It was really interesting. This is maybe a slight tangent, or just from what you presented on, but one of the issues that's quite important in a live debate in Australia is how in different areas of law where family violence is concerned, there might be kind of narratives, particularly in case law, of victim blaming for women, and stuff around the kind of origins and causes of family violence. And I wondered, in the analysis of case law that you've done, whether, I think I saw something on one slide about kind of narratives of fabrication, alienation. Is that something that comes up or for you in the case law that you've looked at? Is there a kind of discourse or narrative about who is responsible for,
Yes.
responsible for violence?
Yeah, so one of the kinds of cases that we excluded from this sample was cases where the mother ends up with a different partner after the case involving family violence, and her new relationship is also violent. I would say that narrative is very present in those sorts of cases. So even if the father with whom the mother has the existing dispute over parenting of their children was himself violent, he then picks up on the fact that mom is with a new partner who may have been criminally charged or whatever, and she's very much blamed, I think, for being seen as making bad choices in her new relationship. So there's a lot of responsibilization, I guess you could call it, or there's different ways you could frame what's happening there, but I think there's certainly victim blaming in those sorts of cases. I haven't seen that so much in terms of the mother being blamed for the violence that's relevant to, like, directly relevant to the issues before the court. But we will be rereading these cases many times, so thank you for that. It's something to watch for, because we may have missed that on the first go round.